How do you know if a witness is lying? You want to know the answer? Come join me on this walk along the beach as I share with you that answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. You know, there's a famous joke that says, oh, you can tell simply because his lips are moving. Well, no, that's not how you tell. So you might be thinking, okay, wait a second. You can tell because there's a lie detector that goes off and a little red warning light goes on every time this person lies. Maybe it's a doctor. Maybe it's somebody who's been sued. Maybe it's an injured victim. No, that's not what happens. That does not happen. There's no lie detector hooked up. There's no lie detector attached to a witness who's testifying either in a pre-trial hearing known as a deposition or during the course of trial. So let's go back to the question I just asked. How do you know when a witness is lying? The answer is you have to catch them in a contradiction. You can't simply say, well, my gut tells me that they're lying, therefore they are lying, so I'm going to treat them as if they're lying. No, that's not how it works. That's not how any of it works. So how would it work? I'll tell you how it would work. Let's say, for example, that my client is an injured victim, suffered malpractice because of a doctor's carelessness, and now goes to the hospital with certain complaints. In the emergency room, the patient is asked a number of things, and one of the things that the doctors and nurses ask the patient is, do you drink alcohol? And the patient says, yes, I do. Now, they ask, well, how much do you drink? Do you drink, once a week, once a month, once a year? According to the hospital record, it indicates that the patient drinks 4 or 5 drinks a day. Okay, so you're thinking, number one, what does that have to do with the malpractice? And number two, why does it matter? Okay? The reality is, in this scenario, this hypothetical example I'm giving you, it doesn't matter. But now, what happens during the course of pre-trial questioning, where the defense attorney is trying to learn information about the injured victim and trying to learn from them exactly what occurred in their own words? So now they're going to go ahead and ask the injured victim, my client, and say, hey, Mrs. Jones, when you presented to the emergency room, what complaints did you make? And now they'll go ahead and explain what they remember complaining about. Okay? And when you were asked the question about whether or not you drank alcohol, what did you say to the doctors and nurses? And Mrs. Jones answers, well, not very often, maybe once or twice a year. So what do you do now with that contradiction? The attorney who is questioning my client, the attorney who represents the doctor or the hospital, will already know what's contained in those medical records. Now they've just heard something that contradicts exactly what's recorded in that particular record. Now you might be thinking, okay, maybe they recorded that information incorrectly. Maybe the patient wasn't in their right mind, wasn't thinking straight. And that could all be true. Maybe it was an error in documentation where they, instead of putting down 0 number of drinks, they put down 4 or 8 or something else. That could be true as well. But now there's a contradiction. And what does the attorney do? What does a good attorney do at that point once they recognize that there is a contradiction? Well, the attorney could do one of two things, at least during the pre-trial questioning, known as an examination before trial or as a deposition. The first thing the attorney could do, and the obvious thing, is to delve deeper. Okay, tell me how many drinks you told the doctors and nurses you actually drink each and every day. Oh, I don't drink anything every day. Well, what do you drink? Oh, I drink some soda, I drink some Gatorade. You don't have any alcohol? No. So now there's another contradiction. Okay, and now the attorney could again continue to delve down into that rabbit hole about how much this person did or did not drink. The alternative is a little bit different. An alternative strategy would be not to do anything, to continue and move on to the next topic. Now, why is that? Well, an attorney who chooses to move on to the next topic and not delve down that rabbit hole of how much they drank and when they drank, now, the reason they would do that is because they want to save that ammunition for trial. They don't want to give my client, the injured victim, an opportunity to go ahead and explain away why the answer that's recorded in the hospital record might be inaccurate. So in that instance, they will save all of these additional questions for trial to try and establish that this witness is being less than truthful. So is there a way to tell whether or not a witness is lying simply because their lips are moving or simply because there's a lie detector sign that goes off? The answer is no. In these civil cases involving accidents and medical malpractice and wrongful death, witnesses are not attached to lie detector tests. They are not reliable. They are not used in civil cases. Credibility is judged by the jury. It's judged by the answers that the witnesses give. And at the end of a case, at the end of a trial, the jury, 6 members of the community, will have to decide whether each of these witnesses, certainly the injured patient, the injured victim, is more credible than not, whether they are more likely right than wrong, that what they are claiming is true. And they're very powerful jury instructions, legal instructions, that the judge gives to the jury at the very end of the case that concerns credibility. And it basically says, listen, ladies and gentlemen, if you find that a witness has testified falsely about one thing, you have every legal right to disregard some of their testimony or all of their testimony. So if you, the jury, believe that a witness has testified falsely, now you can disregard that answer to a question, or you can disregard all of their answers, because you might think, wait a second, if they're lying about one small little thing that's insignificant, how are we to believe that all the other answers this witness gave is appropriate and accurate for the things that really matter in this case? So why do I share this great information with you? I share it with you because this comes up often in every single case, because credibility is the most paramount. It is the most important component of any civil case involving claims of negligence, claims of accidents, malpractice, wrongful death, because the injured patient, the injured victim's credibility is the key to the entire case. You know, I realize you're likely watching this video because you wanted to see the beautiful beach. No, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter happened in New York and you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.